কৰিম যোনকেইটা বহুত important questions and most probably how to solve these questions in the exam tricks কেইটা আমি চাই ল'ম okay so we will begin with our first question. Hopefully I think you have started your revision for the prelims, for the upcoming prelims, and polity is the main subject from where you can just get 10 or 12 questions. Okay, so this is a very important subject for us, so let's just try some questions based on some of the tricks and also based on the knowledge, okay, of concepts basically. Now the first question: which of the following Supreme Court cases is or are related to disputes or conflicts between fundamental rights and directive principles of state policy? Now আমি জানো যে কেইটামান কেसेस আছে বহুত ইম্পৰ্টেন্ট হয় পলিটিত ওকে সো ইয়াৰ মাজৰ চাইটা ইয়াতে দি আছে এই চাইটাও বহুত ইম্পৰ্টেন্ট হয় নাও ওয়ান থিং দ্যাট ইউ উইল ডু টেষ্ট সিরিজ যেতিয়া সলভ কৰা সো ওয়ান আনসার ইউ উইল গেট ওকে আফটার দ্যাট whatever remaining options are there হেকেটাও রিভাইজ কৰিবা তোমালোকে. So that becomes very important for us. So we'll start with the first question. So IR Coelho case 2007. Basically this case was of 9th schedule as we know. Okay. So since this case was of 9th schedule, that means this is not related to fundamental rights and directive principles of state policy. So that means our option number 1 is cancelled out. So we'll eliminate option A and option D. Okay. So we are remaining with two options B and C. So we'll look over the second option, that is the Golaknath case 1967. So yes, the Golaknath case was related to fundamental rights. This was about the amendment of the fundamental rights. Okay. So it was said in this case that the parliament cannot amend the fundamental rights which are sacrosanct in nature. Okay, so this was related to fundamental rights. That means for the implementation of DPSP, the fundamental rights which are sacrosanct in nature, that cannot be amended by parliament. This means in this case this was the decision that was given, and after that you will see the 24th amendment act came up by the parliament to just means recover about this the losses particularly that they have in this particular case. Okay, next is the Menaka Gandhi case. So as we have seen that 2 number is related to fundamental and DPSP, that means we have 2 in option number B. So this should be our answer, but let's see the other options also. Now Menaka Gandhi case, was related to due process of law. Okay, that means the fairness of application of law. So this automatically we can eliminate. So if we eliminate 3, then this option also gets eliminated, and this is our answer, that is 2 and 4. Okay, since you eliminate 1 and we see that 2 is already in this particular segment, fundamental rights and DPSP, so we got our answer. But for the confirmation part, let's we have just read the third one also. Okay, next আমি একবার sign off number 4, Minerva Mills case. Now Minerva Mills case decision was that the means bedrock of democracy basically lies between a balance of DPSP and fundamental rights. Okay, so this is our first question. We'll move on to the next. Which of the following DPSP represent the ideology of liberalism? Okay, yate liberalism akol khudise. Okay, so we'll focus on that only. Liberalistic principles, education for all children between the age of 6 and 14. Number 1, we know that education for the children are provided in DPSP, but yate eta kotha amar notice koribo lagibo that the age particularly is given 6 and 14. So we know in DPSP it's up to the age of 6. Okay, only up to the age of 6 diya ase, not till the 14. Okay, that is in fundamental rights, which is different, but they are asking about DPSP here. So number 1 we can cancel out. So if we cancel 1, then we eliminate this option, that is option A and option D. So we have only this and this left. So 2 and 3, that means 3 is confirmed, the 3 is there. Okay, because in both of the options there is 3. Let's just see number 2 whether it will be correct or not. Separation of the executive from legislative in public services of the state. So as we know, this is a separation of the judiciary from the executive and legislative, and not the executive from legislative, isn't it? Because in India the executive is responsible to the legislative, they're not separate entity. The judiciary is a separate entity. That means the second one is incorrect here. Okay, second to amar incorrect hai. So second to the incorrect hai, this option will also get eliminated. So we get our answer as C. So jetia question solve kora test series or words ketat bahut basic ke dhyan diba, because nowadays the questions basically are framed on the words. Okay, eta word the difference create kore. You see this one, They have created the difference with only one word, that is executive from legislative. So it's not legislative, it's judiciary. Okay, so we'll move on to the next question. With reference to the Constitution of India, consider the following statements. First statement is Article 18 places explicit restrictions on the acceptance of both military and civilian titles. Second is Article 18 has prohibitory provisions for both citizens and non-citizens. Yes. Second number two are correct, hai? We know. But the first one, let's see. Military or civilian titles, so is it prohibited? No, as we know that military and academic titles can be taken. Okay, that is based on merit. The titles can be taken, and the military titles also can be taken. That means this Article 18 about which places explicit restrictions on the acceptance of both military and civilian titles. So this is incorrect. Military or academic titles get accept koribo pare. Okay, so one is incorrect here. If one is incorrect, then we get our answer, that is 2. This 2 is correct. It has prohibitory provisions, and that is for both citizens as well as for foreigners. Okay, foreigners or Karna, they need to take permission from the president before granting any type of titles from any anybody. Okay, or from outside also, if they are getting any title, they have to take permission from the president first. So it this one particularly is correct. That is 2 only. Okay, next. Which of the following directive principles is or are based on the Gandhian principles? Now it talks about Gandhian principle. First we have seen about liberalistic principles, and this one is asking about the Gandhian principles. So let's see the first option: to promote equal justice and to provide free legal aid to the poor. So this is in Article 39. Basically this one talks this one goes for the socialistic principles and not the Gandhian principle. This is a socialistic principle. Second one, to raise the level of nutrition and the standard of living of people and to improve public health. Similarly, this one also is a socialistic principle and not a Gandhian principle. So much the 1 or 2, we eliminate this one. So A2 amar cancel hobo. Okay, A2 cancel hobo, and this one also will be cancelled. That means this is only our remaining answer. Okay, এনেকুৱাকে easily solve কৰিব পাৰা. But actually nowadays this pattern actually sometimes they ask you like this type of questions, but nowadays they give you like only 2, okay, only 3. So এনেকুৱা type of questions আমি কৰিম next session ত এনেকুৱা type of questions কৰিম where it is given only 1, only 2, only 3, this type. Okay, so এনেকুৱা যদি আহে eliminate কৰি আমি easily কৰিব পাৰো. Next session ত we'll see that only 2, only 3 এনেকুৱা যদি statements থাকে তেতিয়া আমি কেনেকুৱাকে কৰিম. Okay, so the next question. Consider the following statements regarding Article 13 of the Indian Constitution. First, it creates scope for reviewing both pre-constitutional and existing laws. Yes, this is correct. It actually means give a scope for reviewing both the pre-constitutional and existing laws. Currently, the amendments made under Article 368 are not laws within the meaning of Article 13 and hence cannot be challenged. This was there earlier. Okay, agote asile, but after the Keshavananda Bharati case, basically this was removed. So that means both of the statements are correct here. So we'll go with C, that is both 1 and 2. Okay, next. Which of the following is or are the significance of fundamental duties under Part 4A of Indian Constitution? Okay, they serve as a warning against anti-social and anti-national activities. If you know about the fundamental duties, obviously they serve as a warning for the anti-social activities and anti-national activities like burning of the flag, etc. These type of activities are prohibited under these particulars. So that means this is correct. Second, they help the courts in examining and determining the constitutional validity of a law. Yes, this in 1992 Supreme Court came up with a decision, came up with a judgment that the fundamental duties, and if any like any person, they hamper the for sovereignty of our nation, okay, the security of our nation, then at that particular term the court can look up on the fundamental duties for examining and determining the constitutional validity of a law. Okay, third, they protect the liberties and freedoms of the people against invasion by the state. This third statement you see by the state, that means government, remember. Okay, so this one particularly goes for the fundamental rights and not the fundamental duties. They do not protect the liberties and freedoms of the people against invasion by the state. This is done by fundamental rights and not by fundamental duties. Here they are asking about fundamental duties, that means only 1 and 2. This is correct. So option A here, 1 and 2, this is only correct. Okay, third one goes for fundamental rights. Fundamental rights basically means talks about the like arbitrariness of the state. If state hampers any like fundamental right of a citizen, then how you'll get the protection, that is in fundamental rights. Okay, next, then, which of the following two directive principles of state policy have been given precedence over fundamental rights under Article 14 and Article 19? So this is very easier. This one you see Article 39B and Article 39C. Basically, equitable distribution of resources, which is in DPSP, and next the concentration of wealth. These two things. Okay. So to implement this, generally, so the question basically belongs to this has been given precedence over fundamental rights, actually 39B and 39C. Next, with regards to the ordinance making power of the president, consider the following statements. The ordinance making power कोणतो article होता है, please comment down in the section. Okay, so first statement is it can repeal or modify any act of the parliament. So yes, it can do. Second, it can be issued retrospectively. That means backdate koi kini ordinance apply koribo pare niki. Yes, it can be applied. Okay. One thing you remember, it can also amend a tax law. Okay, ordinance can also amend a tax law. So two things will answer. The first one, that under which article the ordinance making power of president comes up. Okay, and second, after like if the legislative Lok Sabha is not in session, let's say, and after setting, okay, after the session has been set, so up to how many days this, if they do not, if they disapprove, for how many days it can continue this one. Okay, hopefully, I think you will be able to answer if you are revising. Okay, next, it can be issued retrospectively. I just told this one. It can be issued on subjects enumerated in the state list under ordinary circumstances. Now, এতিয়া মনত ৰাখিবা পাৰ্লিয়ামেণ্টৰ যি power আছে, generally president or ordinance making power is kind of similar to that. So in ordinary circumstances, the president will not be able to make laws on the state list. Okay, we have seen there are 5 different circumstances on which the parliament becomes like parliament has the authority to make laws on the state subject, but not otherwise, not in normal circumstances. In case of national emergency, or when the Rajya Sabha make a resolution when 2 or more states, they just request the parliament to make any kind of law. So these are the conditions that is required to give a like to make a law on the state subject, but not under normal circumstances. Similarly, the ordinance of a president cannot also be made in a state subject in a ordinary circumstance. Okay, that means this is incorrect here. So 1 and 2 is correct only, so that means A. Next, consider the following statements regarding the directive principles of state policy in the Indian Constitution. It is the duty of the state to apply these principles in making laws. Yes, it is correct. Second, the directive principles are like the instrument of instructions enumerated in the Government of India Act of 1935. So both are correct. Okay, this is a very general statement. So both are correct here. Next, the framers of the Indian Constitution made the DPSP legally non-enforceable. Which of the following is or are the reasons for it? These are very general questions. Okay, very easier questions. First one, India did not have sufficient financial resources. Yes, all of us know this thing. So this is correct. Second, the presence of vast diversity and backwardness in the country. Yes, this one is also correct. So both, here also both. Okay, so yeah, this was the last question. So this test series that we have conducted with very basic question first and very important also. Okay, so as you have seen that how to see the questions. So if you're not going with the option, let's say if I give you a choice that we are not going with the option like 1 and 2 or 2 and 3, because nowadays we see the pattern of the options are changed, only 1, only 2, only 3, or none of the above or all of the above. These type of options are there. এনেকুৱাকে options কেইটা থাকে. So আমি বেশি যদি আমার concept clear হয়, then it is good for us. Okay, so key important topics আমি চালো ইয়াতে. Fundamental rights first thing, second thing DPSP, Third are the cases particularly which are related to fundamental rights and DPSP, and also preamble. Okay, today I have not added questions of preamble, but in the next class I will add questions of preamble, and তাতে আমি options কেটা change করে দিম. So আজি just basic or কারণে to understand, so we how to solve the questions particularly we have added these options. But এনেকুৱা options আহিব, এনেকুৱা options আহিলে easier বেছি হৈ যায়, but যদি only one only two এনেকুৱা থাকে, we need to know all the statements there. Okay, so this pattern UPSC has changed the pattern, so APSC will also follow the similar pattern. So we are expecting that that type of questions will generally come up where we need to know all the statements, whether they are correct or whether they're incorrect. So এটার উপর আমার major focus হবো words কেটার উপর. Okay, each and every word of the question particularly you take time. Okay, এতিয়াৰ পৰা টেষ্ট সিরিজ সলভ কৰা, এক্সামত ইমান টাইম নালাগে. Okay, if it is 2 hours in exam, you solve it in 1.5 hour. Let's say you are taking 100 questions and you try to solve within 1.5 hour. Okay, and by that you give a little bit timing to the questions. While you read the question, you just read it is asking you about what. Okay, second, when you read the statements, each and every word you will read and you will try to just remember the thing that whether this is talking about this thing. Okay, so this word specifications is necessary nowadays to just go through the statements like only one, only two, only three. So আমার decide হবো এনেকুৱাকে যে words কেইটা আমি ভালকে পঢ়িম. So if it exactly goes with the particular thing that you have read, okay, you have revised, then you go with that answer. Okay, otherwise do not. So আজি তো আমি just basic ৰ কাৰণে 10টা questions লৈছো. Next class again will come up with polity maybe or another subject, and with more difficult questions, with more standard questions, but as per our APSC pattern. Okay, because some questions will also try to add with current affairs. Okay, some of the questions related to polity of current affairs will also add in the next series. Okay, so for today we'll end, and if you have any queries you can comment on the comment section below, and you can also call on the numbers given. And thanks for watching.